Today we are here to examine the antitrust exemption granted under the Sports Broadcasting Act of 1961 and whether it continues to serve the interests of American consumers. The Sports Broadcasting Act was enacted at a very different time in American history. In the late 1950s and early 1960s, professional football was still developing into a national enterprise. At the time, each team controlled its own broadcasting rights and would negotiate with networks to televise individual games. To promote competition and ensure the success of its league, the NFL amended its bylaws to prevent teams from broadcasting in each other's territory. However, the Department of Justice viewed that restriction as anti-competitive and sued the league for violating the Sherman Act. In 1953, the district court largely sided with the DOJ and issued an injunction preventing the NFL from placing restrictions on televising games in the home territory of a team playing an away game. In 1961, the NFL moved to limit the distribution of games again, signing the first deal to sell broadcast rights for all 14 of its teams as a single package. When the district court again said no, the NFL turned to Congress for help. And just a few months later, Congress passed the Sports Broadcasting Act of 1961, which allowed the leagues to pool their individual broadcasting rights for sale to a single purchaser. The rationale was simple. Congress believed that joint television agreements would help make games more widely available to the public. It also would preserve the competitive balance among the different teams and keep the professional sports leagues financially viable. In exchange, Congress sought to maximize the public interest by limiting the exemption to only, quote, sponsored telecasting, ensuring fans continue to have free access to their favorite sports teams. 65 years later, however, it is fair for this body to ask whether the professional sports leagues have kept up their end of the bargain. In my opinion, they have not, and sports fans are paying the price because of it. The NFL, for example, boasts that 100% of its, quote, local market games, unquote, are available free, over the air, and that it offers the most fan and broadcaster-friendly model in the entire sports and entertainment industry. But how it chooses to define local market games each week leaves fans across the country guessing whether they'll be able to see their favorite team on TV or whether they need to buy a subscription. For example, according to the NFL's distribution schedule for Week 3 games last season, fans in southern Indiana would not see the Indianapolis Colts on their local market. Same for Houston fans in Northeast Texas. Despite living in the same state as their favorite football team, fans are subjected to arbitrary restrictions imposed by the NFL that force them into buying a premium subscription model. This is precisely why NFL Sunday Ticket is advertised to fans as necessary to ensure they could watch every regular season game of their favorite team. The NFL's claim of a fan-friendly distribution model also defies the reality experienced by millions of NFL fans nationwide. NFL fans generally have access to only 3 or 4 games on a Sunday afternoon, with the rest available only through Sunday Ticket. Compare that with the current college football model, where fans can access dozens of games across various television channels on a Saturday afternoon. Since 2021, the NFL, along with the other sports leagues, have stretched the bounds of its exemption to sign exclusive distribution agreements with streaming platforms, including Amazon Prime, Netflix, Peacock, and ESPN. This includes the Green Bay Packers games on Thanksgiving evening and Christmas Day, which will be broadcast exclusively on Netflix outside of the local market. It has also begun shifting some programming to Saturdays, which goes against the original intent of the law, which was to preserve Friday night high school and Saturday college football. Consumers who wish to follow their favorite teams increasingly find themselves paying for multiple services, navigating fragmented viewing arrangements, and facing higher overall costs. According to Fox News, to have access to all NFL games in the 2025 season, it would cost the average sports fan at least $575 or upwards of $800 for those without existing subscriptions. To which all in-market MLB games can likewise cost the consumer upwards of $500 annually, according to the news site Kiplinger. A sports fan without a traditional linear TV package must now have, on average, 4 different streaming services to watch the bulk of major sporting events. The Sports Broadcasting Act was designed to facilitate the distribution of games through free, over-the-air television. It was not intended to provide a perpetual shield for leagues to coordinate the sale of media rights across every new technology and distribution platform that emerges. Yet that is effectively what has happened. Today, the major leagues, and particularly the National Football League, have used the antitrust exemption to collectively negotiate increasingly lucrative media distribution contracts that go far beyond the circumstances Congress contemplated in 1961. Following passage of the Sports Broadcasting Act, then NFL Commissioner Pete Rozelle signed a TV deal worth $4.65 million. Nearly 60 years later, the NFL signed an 11-year media deal worth $113 billion. The NBA, first TV contract after passage of the SBA, was for $27 million. In 2024, the league signed an 11-year deal worth $76 billion. While the leagues are undoubtedly more popular than they were in 1961 because they do not follow America's antitrust laws for television agreements, they can charge consumers inflated prices that would otherwise be illegal. The NFL argues that its distribution model is needed to maintain competitive balance and keep teams financially viable, and that's fair. I think most sports fans appreciate it when teams can compete on the merits rather than through an arms race like what we're seeing today with college football. But the NFL and its teams are not in the same financial position as they were in 1961. Under the NFL's first media distribution contract, each team received approximately $310,000 per year. In 2025, each team received $416 million from the league's national media, sponsorship, and licensing revenue. Not to make it personal, but Commissioner Rozelle's salary in 1961 was $60,000. Commissioner Goodell's salary today is reportedly over $60 million. And in 1999, Dan Snyder purchased the now Washington Commanders for $800 million. Today, despite having only one playoff win in the last 25 years, sorry, Commanders fans, the Commanders are presently valued at over $7 billion. The NFL now reaches hundreds of millions of fans across dozens of international markets. The NFL is not a fragile enterprise in need of special protection. It is one of the most successful and powerful entertainment businesses in the world, and it pays its players and staff accordingly. To suggest that teams could not remain competitive without an antitrust exemption is simply false. It also falsely suggests that Congress, not the NFL, controls revenue sharing, which is also inaccurate. But the question before Congress is not whether professional sports teams will continue to compete without this exemption. The question is whether consumers continue to benefit from it. The evidence increasingly suggests they do not. The NFL's ongoing Sunday ticket litigation further illustrates this point. In 2024, a jury found the NFL guilty of violating antitrust law for colluding to limit consumer choice and charge super competitive prices for access to games through its Sunday ticket platform. The jury awarded plaintiffs a judgment of over $14 billion against the NFL. This ruling is currently on appeal, but regardless of the litigation's final outcome, the allegations themselves reflect a broader reality. the NFL has used its unique ability to coordinate amongst otherwise competitive clubs to maximize revenue rather than expanding consumer access. Congress only grants antitrust exemptions in rare circumstances because competition remains the best mechanism for promoting innovation and protecting consumers. Exemptions should be maintained only when there are benefits that clearly outweigh the costs. When the beneficiaries of an exemption begin using it to restrict access, increase prices, and strengthen their own market power beyond what Congress intended, lawmakers, Congress, have an obligation to reconsider whether that exemption remains justified. The Sports Broadcasting Act was enacted to expand access to sports broadcasting, not to facilitate exclusive streaming arrangements that force fans to pay more for less. In my view, the NFL seems to have lost sight of the original purpose of the legislation, and in fact, they may even be in violation of the law right now. Today, I hope we can have a constructive debate about what reforms, if any, Congress should consider to ensure a marketplace that works best for consumers.